Ashley Benefield, a former model and ballerina, finding herself at the center of a high-profile trial after being accused of shooting and killing her husband, Douglas Benefield. Claiming self-defense, Ashley's case sheds light on the complexities of domestic violence and the legal challenges that arise when trying to prove justifiable force. All this weekend on the Hidden Killers podcast, we're examining the case of Ashley Benefield, examining the events leading up to that fateful day in their Lakewood Ranch, Florida home, and the allegations of abuse Ashley made against Douglas. We're taking you to the courtroom for raw audio from the Stand Your Ground hearing of Ashley Benefield all weekend here on the Hidden Killers podcast.
All right, Madam Court Reporter, we are back on the record after the break. And yeah, let's go ahead and take care of States 45.
Yes, the state would ask to move it into evidence.
Defense.
Text messages. Yeah, these are the text messages which
Correct. Yes, sir.
we rejected because of relevance, and we still believe them to be relevant, but as Your Honor has noted, no jury, so however the court wants to treat it.
Relevance.
Judge, the relevance is the tenor of their relationship. This is all after she's made all of these allegations against the defendant, against the victim, and all of them have been shot down, and then she's telling people that she's afraid of the defendant, or of the victim, and she's afraid for her child, but yet she's having these text conversations with him that clearly there doesn't appear to be any fear, and it helps set the tone for their relationship.
All right. There was also, I know relevance was now, but there was also the objection to hearsay, not as to, obviously, the text attributable to the defendant, right, come in.
Right.
But what about the argument that any text by what's alleged to be Mr. Benefield hearsay?
I would have to know which text specifically, but like for instance, he says trucker on the way as the last text. So my argument for that would be statement of intent, that hearsay is allowed to come in if it's a statement of intent by a witness and the state is trying to show that the witness complied or acted in compliance with that statement. So that would be my response to that. The other ones of good morning, good night, those aren't offered for the truth of the matter asserted. All
right. Yes, sir, Mr. Taylor. So there's your answers to your two objections. So anything else you want to put on the record, sir?
I don't believe so, Your Honor. I'm a lot more concerned with the next witness that I'd like to take up with the court.
All right. Well, there's some foreshadowing for you. Okay, I'm going to allow it. I'm going to overrule the objections defense. States 45 is admitted, that being the text messages. I find them relevant solely for the purpose of the state's argument, and that's the only way that I'm going to take them, because that's why the state has said they're offering them, is just to show the nature and tenor of the communications and the relationship between the parties in the days leading up to the event. And as to hearsay, certainly any statements made by the defendant or attributable to the defendant as part of this text messaging would be admissible under the rules. And as to the other ones, again, I don't find that they're offered for the truth of the matter asserted. With the good night, the good morning, what do you need at Lowe's? You want to go to Panera? I'm taking it solely for the purposes that the state has said they're submitting it. So I will overrule on that. All right, sorry about that. I got my papers out of order and started numbering incorrectly. So now I'm good to go. All right, who is the next witness?
The next witness is Detective Brian Moreland. Is that?
So if there's concerns, let's hear them now, I guess. If they're general concerns as opposed to discrete portions of his testimony.
I think this witness marks the beginning of the down the rabbit hole that we were hoping to avoid, only because this is the detective, Judge White, that was assigned to the DCF cases and the allegations of abuse by Mrs. Benefield against Mr. Douglas Benefield. And I don't think it has any relevance whatsoever to the proceedings. I think that we're going to end up in a dispute as to what the conclusions were, that is to say, unfounded, unsubstantiated, as opposed to ridiculous or nonsense, that kind of thing. It's one thing when something is not proven by insufficient evidence. It's quite another thing when it is determined to be unfounded. I don't know that any of the DCF people who actually made the decisions are going to be present to be able to be cross-examined. And I think even if they were, I don't think that that's a road that we want to go down because, again, I don't think it has any relevance to the proceedings at all. Even if we give the state the benefit of their theory in creating motive and showing what they want to show, such as the text messages between the parties that they were getting along, I don't know what the substance of the abuse allegations lends to that.
All right, let me just say this. That's where my mind is going, but I don't know anything about these allegations. I don't think it's in any of the paperwork.
I can tell you, Judge, my intention, and it's for the same reason that I entered Judge Moreland's oral order for the previous things. I do not intend to get into anything other than there was a complaint, who investigated, was it sexual abuse or physical abuse, and against who, and then was it investigated, and did this detective close the case? Or, file the case, or how did it work?
Okay. Let me get a little bit more. Oh, hold on. As you may have noticed, I'm pretty big on procedure. And so I go with proponent, and then I come back to the non-movement or non-proponent, and then I come back for rebuttal. So when I come to you, tell me everything you want to know, because I don't ping pong back and forth.
Apologize.
But I have questions.
Yes.
Because I don't know anything about this. Who are the complaints against?
The complaints are the defendant making complaints of sexual and physical abuse against the victim.
Regarding what child?
The same child, Emerson.
Emerson.
Yes.
Because I've heard about an older child.
Yes.
And
we will
Emerson.
establish that.
All right, so these are complaints made by the defendant
Yes.
against the decedent
Yes.
regarding their natural
Their
child.
natural child who was a toddler at the time.
When were they made?
I have the dates. December 10th, 2019. March 21st, 2020. March 23rd, 2020. April 5th, 2020. And April 27th, 2020.
Oops, sorry. All right. So tell me, what is your theory as to why these tend to prove or disprove any material facts that I need to consider?
Well, to me, there are two issues. There's credibility, ultimately the credibility of the defendant, because we have to take the facts as known by her, or at least as she's saying. So the credibility of the defendant is an issue. So some of these things that I'm getting into go towards the credibility or lack of credibility. These things also go to the motive for this, because the defendant attempted in court over and over and over to stop this communication with the child, and Judge Moreland stopped that. So she changed tack and then went to abuse against the child as opposed to supposed abuse against her. And she attempted for the abuse against the child. And she even makes comments to a witness that we're going to have later on that nobody will help me, what am I going to do? Nobody will listen to me, because these reports were not being filed by law enforcement. And then at the time, all of this is going on at the time they're goodnighting it in the text messages. So
all of what's going on?
These complaints are going on before the text messages were there.
Yeah, I was going to say, because those are from the week before.
They're from the week before.
These are months before.
Yes. So these had already been made. I apologize. These had already been made at the time that they're talking like they are here. And her argument is, I just want to save my child. That's the only reason I'm around him. This is all going to come out later on. And otherwise I would never be around him. Nobody will listen to me. I have to move to Maryland to get a new family jurisdiction. So this goes into everyone. She had exhausted, in the state's opinion, every avenue that she could to keep this man away from the child. And when she felt like no one else was going to do anything, this was the result.
All right. Anything else?
No.
All right. Now, sir.
So, Your Honor, you wear the robe. But all I can say is, as I tried to explain in my opening statement, the parameters of the Stand Your Ground statute require the state to prove by clear and convincing evidence why the force used was not justified. I don't see how motive has anything to do with that. I also don't respectfully see how complaints about abuse have anything to do with that. And what I'm particularly concerned about, and the reason why I think it's going to be, to a great extent, a depletion of the court's time unnecessarily, is that this detective was not the one who received the complaints. That would have been DCF. So this detective, whatever he has to say, is going to the extent it's substantive, is going to be based on rank hearsay. That's number one. Number two, I'm concerned about this detective offering an opinion as to how the case was closed. Assuming the court were to allow it, I could understand if the state asks, and was the case closed? Yes, okay, next. On the other hand, I could not understand if the question is, how was the case closed? Well, it was closed as unfounded. In other words, there was not a scintilla of truth to it. How am I going to cross-examine this detective based upon that conclusion, which was rendered by somebody else?
All right, so what I'm hearing is this detective, he's a CAC?
Yes.
All right, crimes against children. A complaint was made?
Yes. To the sheriff's office.
By the defendant?
5 times, yes.
Hold on. For each individual complaint?
Yes.
Complaint was made by the defendant on such and such a date against the decedent, just a very broad category alleging some sort of abuse against their natural daughter. It was investigated and it was closed. Right? That's all you want.
Judge, I believe its effect on listener the same as Judge Moreland's order, the fact that it was closed unfounded. That is the part that has an effect on the defendant. I'm not offering it to prove that there was no evidence of it, just that the defendant.
And this is the weird thing, because I've heard that now. But I think the point is, what your point is, it was closed and no action was taken. Whether it was unfounded, unsubstantiated, fanciful, improbable, I don't even know what I do know unsubstantiated, unfounded. No, I think those are the big ones. I'll allow that. I'll allow the fact it was closed with no action taken.
If I could just let him know.
Let him know, and I'll prepare the curative instruction for the jury.
Okay.
But at the end of the day, I understand, and this is what I was saying earlier to the defense is, I understand the point you're trying to make. I get it. I know where you're going. No problem. I'm with you. I'm following you. The same as with Mr. Taylor. I just think there's a much more direct way to get there.
Okay.
All right. In fact, quite frankly, if that's all it's going to be, there could probably be a stipulation here. But that's all I'm going to allow. And then you can argue at the end, and you can argue at the end the opposite side.
Okay.
Okay. That she was absolutely privileged to make these complaints. And she must have had a good faith basis to do so, and so be it. There was no action taken.
I would have a problem stipulating to that.
Judge, I would rather call the witness.
That's fine. And I'm not. Listen, I just threw that out there. You know how I sometimes do things gratuitously, which I shouldn't. So go ahead.
State's calls Detective Brian Moreland.
I'm prone to gratuitous musings.
I just want the court to know I tried to save the court time.
No problem.
Face the clerk, raise your right hand this morning.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Yes, ma'am.
Oh, did you get a chance to go talk to him?
No, but
Just stay about 12 inches.
I'll lead.
Gotcha.
Okay. On that one issue, I'll probably allow a little bit of latitude on leading just to keep it clean. Hello, Detective.
Hello.
Sir, make yourself comfortable in that chair. Adjust that microphone up, down, left, right, however you need. Just a loud, clear voice. We should pick up everything.
Thank you,
sir.
Please state your name.
Detective Brian Moreland,
Where do you work?
Manatee County Sheriff's Office.
Okay. Are you any relation to Judge Moreland?
No, ma'am.
Okay. How long have you worked for Manatee County Sheriff's Office?
Since 2004.
What is your current position?
I'm a crimes against children detective.
How long have you done that?
Since 2011.
And what does a crimes against children detective investigate, just generally? What kinds of crimes?
We take general assignment, so any kind of abuse, neglect, death investigation, sexual abuse, things like that. Anything that happens to anybody under the age of 18 years.
Okay, so of children.
Yes.
Okay. When you investigate either of those allegations, either physical abuse or sexual abuse, do other agencies all work together with you?
Other entities do, yes, ma'am.
Entities. Okay, and who are those entities?
Generally, child protection, the child protection team, which is here in Manatee County, and then what I would refer to as DCF, or Child Protection Services.
Okay, so I just want to make clear, you're law enforcement, so you do investigations for criminal charges.
That's correct.
Okay, and if DCF is involved, they are not investigating for criminal charges, correct?
Correct.
Okay. So they have different goals, I
Yes,
guess is my point.
Their goal is the safety of the children involved.
Okay. And CPT is not a part of DCF? I just want to put that on the record.
No, ma'am.
Okay. When there's an allegation of abuse, what is the protocol? Who goes out to investigate first?
Generally, what happens in at least my criminal investigations is once the allegations are made, they'll go through the Florida Abuse Hotline. CPS would get involved, call for law enforcement. Generally, what happens is a uniformed law enforcement deputy goes out and takes the initial investigation. If further investigation is warranted, it'll make its way to our office and get assigned to a detective.
Okay, so, and during this process where there's an initial law enforcement officer, is there typically someone from DCF there? I think you said CPI.
CPI.
Okay, which is a part of DCF.
Yes, child protection investigator.
Okay. So only when further investigation is needed do you get assigned?
Correct.
Okay. Were you in that position, the same position you're in now back in 2019?
Yes, ma'am.
Did you become familiar with someone named Ashley Benefield?
Yes, ma'am.
And her child with Doug Benefield, Emerson?
Yes, ma'am.
Okay. Were you involved in investigating a series of allegations starting back, I guess, in 2017, but really in 19, I guess, is what I want to concentrate on?
Yes.
Okay. Let's start with the first allegation that came in 2019, the date of December 2019.
Yes, ma'am.
Do you recall that
Yes.
allegation?
Mm-hmm.
Okay. And without getting too much into the facts of it, what type of an allegation was it?
That was a sexual abuse allegation.
Sexual abuse allegation, and the allegation was made by?
The reporting party was Ashley Benefield.
Ashley Benefield, and saying who was doing the abusing?
Doug Benefield.
Okay. And clearly you opened up a MSO case number on that?
It was opened by the uniformed deputy.
Already open, okay. So at this time, the uniformed deputy had already gone out as well as the child protection investigator?
Yes, ma'am.
Okay. Do you know if she went to CPT that time?
In 2019, she was seen by Dr. Riley at CPT. Yes.
Okay. And CPT, that is a medical exam?
They perform two functions for us. In my criminal investigations, they do forensic interviews for us and also medical evaluations. Yes.
With respect to what we're talking about with Emerson, she was how old?
She was too young for
Too
a
young.
forensic interview. Yes, ma'am.
How old was she, like 2 or toddler?
Yes.
Okay. After this first complaint came in or allegation came in, did you investigate?
Yes, ma'am.
Did you speak with the parties or speak with Doug Benefield?
I did.
Okay. And did your conversation with him give you any concern?
No.
Okay.
Objection.
Sustained.
And you eventually just closed that case with no charges, correct?
That's correct.
All right. So I want to talk about the second, what I call the second report. Do you know what date that came in?
Are we referring to a 2020 report?
Yes. Yeah.
May I look at my?
Yes. Go right ahead.
The report date on that was March 21st, 2020.
Okay. And that was also obviously given an MSO case number. What was that allegation?
That was a physical abuse report.
Okay. And that was, again, by Ashley Benefield saying Doug Benefield was abusing the child Emerson.
Yes, ma'am.
Okay. To your knowledge, did a deputy and a child protection investigator respond initially before you got it?
Yes, ma'am.
Okay. Before you could fully investigate that case, did another complaint come in?
A few days after that, on the 23rd, another deputy responded to Ms. Benefield's residence and conducted another interview.
Okay, so another allegation, same parties.
Yes.
All right. And what type of an allegation was that?
Also physical abuse.
Physical abuse. And did you investigate both of these reports kind of together?
Yes.
Did you ultimately close that case?
Yes, ma'am.
With no charges?
No charges.
And then the fourth report, can you tell me what date that was?
Report date on that was April 5th, 2020.
Okay. And what was the allegation?
Also physical abuse.
Same parties?
Yes, ma'am.
Same allegations, okay. And again, a deputy and a child protection investigator responded. And at some point you were assigned the case?
Yes, ma'am.
Okay. And again, before you could fully investigate this, did another complaint come in?
That I don't recall.
Okay. I have something dated April 27th of 20. Do you have any notation of that in your file? With Deputy Schrenk?
This is when he responded to Ashley's residence, yeah.
Okay. And so that was on April 27th.
Yeah.
And that was another allegation, correct? New bruises and sexual abuse?
Allegation of bruising and marks. Yes.
Okay. Same parties?
Yes, ma'am.
Did you investigate this case or these two cases?
I did.
And ultimately, you closed those with no charges?
That's correct.
Okay. Thank you. I have no further questions.
Mr. Taylor? Cross?
No questions for Detective Moylan, Your Honor.
All right. Can the witness be released?
Yes.
Yes.
All right, sir, you're released from your subpoena. Thank you.
Sir.
State would call Dr. Broder.
Your Honor, this one we need to have a little powwow.
Okay. Don't bring in Dr. Broder yet. Thank you, Deputy.
Thank you, sir.
All right. Go ahead and put your objections on the record, and then I'll hear from the state.
Sure. Your Honor, for this, I rely exclusively on the Florida Evidence Code, which is really, really clear about character evidence. And I've read these reports. What Dr. Broder is going to testify to about Ms. Benefield and his conclusions clearly go to her character. And the evidence code says in no uncertain terms it's inadmissible until such time as the defense puts her character, if at all, in issue. What is admissible is Douglas Benefield's character. According to that same statute, I gave the court a memorandum on it. I know while I haven't spent that much time before the court, I have spent enough time to know that the court reads everything. So I know Your Honor has reviewed it. I don't think, honestly, Judge, there is an exception to it. And what I'm particularly concerned about is the state is about to call a professional who's going to opine as to characteristics of Ms. Benefield that really have no place in this hearing. And while I firmly believe at the end of the day that Your Honor will parse this appropriately, I have some real concerns about this kind of testimony and whether or not the court would be capable of that. So I think it's improper.
All right. State, what do you expect Dr. Broder is going to testify about?
Okay, there are several things. Most of what I try to keep Dr. Broder's testimony to is his observations of the defendant and the victim and the child. Also things that the defendant told him. So I tried to section this out to sections that I did not believe would be objectionable. But then there is a section where he does talk about some testing that he did, and some of his opinions and diagnoses of her would suggest that she has, it would probably be improper for me to get too far into it, but suggests that she does exaggerate facts, that she does exhibit paranoia about things, and I think that is highly relevant to the self-defense argument. First of all, I believe the defendant has put her character into question by asserting self-defense in the motion, even though we're not technically in trial. But I do agree that character evidence only has certain ways that it can be proven, and that's not what the state's trying to do. What the state is trying to do is the court has to determine if this use of self-defense was valid based on the facts as they were known to the defendant at the time. And as I've argued before, the only person that knows the facts as were known to the defendant at the time is the defendant. And if a professional has investigated her and evaluated her extensively and says she has a tendency to exploit the facts and exaggerate the facts and be a victim when she's not necessarily a victim, I think it goes to the facts as seen by the defendant at the time and the reasonableness of her belief that she needed to use deadly force.
All right, so let's talk about that one first. And you can sit, you don't have to.
Okay, it's just hard.
I understand.
To remember to do that.
And if you want to, that's fine. If you want to stand up and move around, that's fine too.
Okay.
So we certainly have to look at the use of force as informed by the facts and understanding that the defendant had on that day, which sometimes misleads folks into thinking it's a subjective test. It is not. It is knowing the facts that would have been within the defendant's ambit of knowledge at that time. What would a reasonable person have done? So I don't look at what would a reasonable person who tends to exaggerate situations. I'm not concerned with a reasonable person who's paranoid or mentally ill or schizophrenic or any of those. I'm just, what are the facts that were available to and known to the defendant? And were the actions of the defendant reasonable in looking at it from the perspective of a reasonable person? So I guess I'll say that I'm not seeing, and I'll come to you. Don't think I'm not coming over there. I am. But before I go over there, I want to make sure I understand what the testing of the defendant and the diagnosis that she exaggerates and may suffer from paranoia, to the extent that those are diagnoses, DSM-4 or 5, whatever we're on now. So I want to hear a little bit more about that, but also what the observations of the defendant, the victim, and the child, what those are, when were they, and what's the relevance of any observations that witness may have made. Defendant's statement's another issue. I'm not going to spend a lot of time there because if she made statements to him, as long as they're relevant, they're coming in. But those two things, I'm not quite understanding the testing of the defendant and any diagnoses by Dr. Broder and how that's relevant to the objective person standard, and then the observations of the interactions between the three of them.
Okay. Which one do you want me to take?
Whichever one you want first.
Okay. Judge, as far as the testing, I agree that it's an objective standard. But if your only recitation of the facts is told by someone who suffers from histrionic personality disorder and makes herself a victim all the time, then her view of the facts, it goes to her credibility. Her view of the facts as is being put forth in the motion and possibly in this courtroom is not necessarily as reliable.
Let me ask you this. Is the defendant's motion substantive evidence that I can consider?
I think the defense would say it is.
But I'm asking you.
No.
I'm just going to ask that limited question. Is the defendant's motion substantive evidence that I can consider?
Absolutely.
And you have a case that says that. I don't think it's not sworn to, is it?
No.
Now, hold on. Let me say this. I completely understand that in order to make a prima facie case, and I believe this as well, not just I know this is the case law, that a motion to dismiss under the stand your ground statutes does not need to be sworn to. All it has to do is set forth a prima facie case. So, with that said, though, how do I consider that as substantive evidence when it's a motion written by the attorney on behalf of the client, and I don't see any manifestation of an adoption of that?
Well, I can answer that. Number one, the state has stipulated and acknowledged that it meets the prima facie
That's it.
threshold.
That is a pleading threshold.
Yes.
That's not a substantive evidence threshold. All it is a pleading threshold.
All right, and the appellate court has said that Your Honor is obligated to take the averments as true.
In determining prima facie, and I agree, there's a prima facie case. My question is, under what authority, so I'm looking for a statute, a rule, or a case, says that an unsworn motion to dismiss under stand your ground can be considered as substantive evidence?
Well, I think at this juncture, the only inquiry for the court is whether or not the state produces evidence clearly and convincingly that the force used was not justified.
100%. I agree with that.
And that therein exposes, I think, her argument in this sense. Whether or not Miss Benefield exaggerated things has nothing to do with what the state, at least up until now, has yet to produce. I was going to use scintillative evidence, but I'm kind of burned on that one. Has yet to produce any evidence whatsoever, which is the violent nature of Douglas Benefield. And was my client, the objective standard, on that day, knowing what she knew about him, the firing the gun in the kitchen, placing a tracker on her car, was she justified in resorting to deadly force? I've yet to hear anything about that refutes that. I only have heard a case that is intending to show motive.
I appreciate that for your closing argument. My question is much, much more narrowly tailored. Can the court consider the defendant's motion to dismiss for stand your ground reasons that was written by the attorney, is not verified, has not been adopted as a defendant's statement, as substantive evidence? And so we'll leave that right now on the table because I'm not aware of any case law that says it's substantive evidence. But let me come back to you. And I think I kind of got off on that tangent. Based upon the observations, is that where we left off? Or is this still on the testing?
Which one?
I believe it was on the testing.
Okay.
Broder's testimony.
Okay. So, yes, I think that's where we were. We were talking about how the court does have to determine the facts as known to the defendant. And when you're evaluating what's known to the defendant, I think the credibility of how she views things is highly relevant to the recitation of the facts. And so I don't know how the substantive evidence or non-substantive evidence in the motion to dismiss plays into that. The burden has shifted to me. She has said self-defense, so I do feel like we have to prove otherwise. So the fact that she has these traits and has been seen to do it, I think plays into the facts as known to her.
I think if there's going to be substantive evidence in front of me, all I know right now is that a prima facie case has been pled. That's it. Now the burden shifts to the state to prove by competent and substantial evidence that proves clearly and convincingly that the defendant is not entitled to. But I don't think the facts as alleged in the defendant's motion are substantive evidence. I'll look back through my notes, but I know there's been a lot of cross-examination on allegations of prior violence and so forth. And my take on that all has been, well, yeah, I heard about that, but not, yes, that happened, or yes, it's true. I haven't received, I just don't consider that as let's just call it proof. So I think if at some point the defendant's statements are in front of me, whether it's here in court or was it a recorded statement?
Yeah.
Okay. So for right now, I just don't think that beyond the fact that there's a prima facie case of self-defense and now the state has to rebut that. So I'm not, at this point, I mean, there might be rebuttal where Dr. Broder can bring that all in, but at this point I don't think it's relevant to preemptively show that she exaggerates or is paranoid. All right, now on the observations.
On the observations, it again goes to the state's allegation of motive that she is trying everything to get rid of this victim, and she's tried violence against her and it hasn't worked. She's tried violence against the child and it hasn't worked. And so it goes to her credibility and motive that she's telling the the victim one thing, she is acting another way in private. It shows that she is being manipulative and she is not at all wanting to have this nice family relationship, which goes to her motive to get rid of him. She doesn't want him around.
All right, let me take even a further step back, and this is an example of where you guys know the case so much better than me. What observations do you expect Dr. Broder to testify to? I saw it on this day. I saw this.
The seeing is mostly with the child, because the allegations were of abuse, and the seeing is the child interacting with mom and dad. The rest of it is the defendant's statements.
All right, so the observations, I'm only talking about that right now. The observations portion, which was number one of the testimony you intend to elicit from Dr. Broder, is that he observed the decedent interacting with the child, Emerson, presumably in a positive way.
Yes.
And the child didn't exhibit any external manifestations of fear or...
Correct.
Okay. When were these observations made?
And I have to look at my questions, but the report was set to come out. It came out, I think, a week before he was killed. So he met with them 10, 15 times. So I'm not sure exactly what date, but I can tell you when he was asked to do the report, when he was assigned to do the evaluations of the two of them. It was... I don't have the date. Hang on, Judge, I'll find it. Trying to find his report, Judge. Here. I believe it was spring into summer of 2020. But like I said, he saw them on numerous occasions, so.
And your intention of offering the evidence of the observations by Dr. Broder of the interactions between the decedent and his daughter is just simply to show that she didn't seem afraid or scared of him.
Correct.
Right. So that should be one question.
I think he's entitled to say why he thinks that.
Well, I mean, yes. What did you observe? Because otherwise it's conclusory.
Right.
But he's got to put the facts on there. But
Right.
okay. And I'm going to come to you in a second to hear your other portions. And then on the defendant's statements, I mean, how numerous are these? If they met 12 times, are we going to hear hours worth of defendant's statements?
No, I don't know how long it's going to be, but there's several statements.
Okay. I don't know what they are. All right, sir, Mr. Taylor, so I've already said I'm not going to allow the testing and the diagnosis until I think there is substantive evidence in the record of defendant's statements or character that would allow that to be used. Maybe in rebuttal, we'll see. But now to observations. Did you want to be heard on the observations of Dr. Broder?
Well, let's assume, I think the court got to it right quick. Let's assume that he's going to come in and he's going to testify. I observed Douglas Benefield with Emerson, and Emerson appeared to be quite happy. Okay, so that's, I guess, another way of establishing that the complaints were closed with no finding. So it's, I guess, reinforcing the state's establishment of motive. So the question becomes, for something that's not an essential ingredient of this hearing, that does not go to one of the facts and issue, just how much reinforcement to a non-essential element is the court going to allow? I don't think that there's a thing that Dr. Broder is going to say about observing the interaction between the father and his daughter that's adverse. I think the court figured that out pretty quickly. So then the question is, so what's the relevance of it? What's the benefit of it? What's material to it? Because it does not run to supporting any fact and issue. What I do think, Your Honor, is that if she is allowed to call Dr. Broder and Dr. Broder is allowed to testify, I believe I can question Dr. Broder about his conclusions as they related to Douglas Benefield. I think that the evidence code clearly provides for that. I have alleged that Douglas Benefield was violent. I've attached to our motion, which I think the court can consider substantive evidence, admissions by Mr. Benefield under oath. And I think that I am entitled to bring out from this psychologist who the state is going to call that he concluded Douglas Benefield suffered from obsessive control, obsessive compulsive personality, and that somebody with that diagnosis likes to control their circumstances, their situation, which would include, according to Dr. Broder, quote, their marriage, parenthetical, Ashley, end parenthetical, quote. Dr. Broder also here's Ashley's chief complaint, which is that he's violent, he's jealous, he's manipulative. These are things that she feels. If the state wants to go down that road, I think then I'm entitled to cross on it.
All right. I don't know because I haven't heard his testimony yet. It may be within the scope of direct, and it may be outside the scope of direct. I don't know how far they would get into that. I think that's more of a game time decision. All right, State, any final thoughts?
No, I just want to put on the record that I disagree that if I do get into certain things about the defendant, that it opens the door naturally to talk about his impressions or diagnosis of Doug. I think I would like to see that ruled out.
And that's why I said I don't know. Because I don't know what his testimony is going to be. Certainly, it's something that could happen. I don't know. Maybe it's relevant to some issue you raise. I don't know. But more specific to the observations that Dr. Broder made regarding the interactions between the decedent and the child, the ruling is much like I just made with Detective Moreland. If you want to get a little bit at, and let me be clear, if I'm understanding how this is going to come full circle, that a couple of days before, this is what I'm understanding from you and from what I'm piecing together as we go forward. A couple of days before the incident alleged in the information, Dr. Broder issued a report, and that the defendant would have seen that report, seen that Dr. Broder made positive observations regarding the interactions between the victim and the child, and that supports the state's theory of why she did what she did.
Your Honor, I'm sorry to interrupt, but Ms. Benefield never saw the report.
And that's what I'm trying to understand.
Right. That they did a joint motion to disclose but they had not seen it. I would agree with that.
All right. So what again would so then here's where I'm left. Dr. Broder comes in and he says, around the same time that in the spring of 2020, that...
And I'm sorry, Judge, I did find the date. It's June 1st, 2020.
June 1st of 2020 is the order appointing him.
No, that's when he started his evaluation.
There is more to come in the Ashley Benefield Stand Your Ground hearing. We're bringing it to you all weekend long here on the Hidden Killers podcast. Press subscribe so you don't miss a minute of courtroom coverage. I'm Tony Bruschi. Stay with us.